Obscenity is one of the few categories of speech the First Amendment does not protect. The Miller test, 3 prongs, tells you when something crosses into that unprotected zone. Sex and nudity content can be obscene, violent content cannot. I want to spend a few minutes on why. Roth in 1957 said obscenity is not protected. Miller in 1973 gave us the 3-prong test. Both cases involved sexual material. The unprotected category, as the court is built, is about sex, not violence. That distinction surprises students, and it surprises a lot of state legislators too. In 2005, California passed a law banning the sale of violent video games to minors. The law defined a violent video game as one that lets the player kill, maim, dismember, or sexually assault an image of a human being. The legislature thought, this is like obscenity for kids. We can regulate it in the same way. Brown versus Entertainment Merchants Association reached the Supreme Court in 2011. Justice Scalia, 7-2, said no. The court refused to create a new unprotected category for violent speech. The First Amendment, Scalia wrote, doesn't have a freewheeling authority to declare new categories of speech outside the scope of protection. Here's the rule from Brown that every communicator should keep in mind. The court hasn't added a new categorical exclusion from the First Amendment protection since the Roth-Miller line in 1957. Not for violence, not for false statements about wars, not for cruelty to animals. The categorical exclusions are basically frozen at where the court left them 60-plus years ago. What that means in practice is, when a politician proposes a new speech regulation, your first question should be, what unprotected category is this hooked to? If the answer is, we want to create a new one, the answer is usually no. Brown is the cleanest modern statement of that rule. The Activity Board has a Miller fact pattern this week. Apply Miller, then ask whether Brown changes your answer, and I'll see you there.